This is a Miner's Minute, a conversation with James Buchal, a mining attorney. James, can I ask you a little bit about Oregon here? You're working with EOMA, and that case has been going on for quite a long time, and maybe you could give a little history and then a little bit about where the disposition of that case is now.
Yeah, that's a very sad case. When Congress passed the Clean Water Act, they had two general types of permits. There were 404 permits for the discharge of dredged material and 402 permits for the discharge of pollutants, typically industrial pollutants. For many years, the Corps of Engineers would issue permits to suction dredgers and other miners who were dredging, and these are simple little permits. Down in California, they were general area permits. But sometime in the late 80s, the evil Clinton administration had the EPA somehow take the jurisdiction away from the Corps, and all of a sudden they began to assert that this stuff was to be done under Section 402. Section 402 has to do with the discharge of pollutants. It has all kinds of requirements that don't make any sense in the context of just dredging stuff up that was already in the river and putting it back. So our first case was about 5 or 6 years ago when the Oregon Department of Environmental Quality, acting on delegated authority from the U.S. Department of Environmental Protection Agency, decided to issue one of these 402 permits, which was fairly restrictive and had all sorts of problems with it. And we brought suit saying, wait a minute, you're in the wrong law. You should be doing a 402 permit, not a 404 permit. We thought we were helped along the way because the summer before the Court of Appeals made its decision, the United States Supreme Court came out with a case out in Alaska that said either it's a 402 permit or it's a 404 permit, but it's not both. Unfortunately, the Oregon Court of Appeals, for reasons that we have yet to understand, decided that maybe the stuff coming out of the dredge could somehow be split into two different things, and the rocks and gravel that fell down quickly could be under a 404 permit, and the stuff that sort of didn't fall down quickly and went further down the river should be a 402 permit, and so we should have a double permitting regime. We attempted to get the Oregon Supreme Court to review that. The Supreme Court granted review and then rejected the review when the state said, aha, the permit expired, start all over. So where we are now is starting all over. And we're going to present the same arguments, and this time we'll present some additional ones that are sort of fairly technical and arcane arguments having to do with the construction of the Water Pollution Control Act. And that case is meandering along fairly slowly because one of the first things that the clients wanted to do was to challenge the standing of the environmentalists. And so we're in the midst of fairly extensive discovery and obtaining gigabytes of information about all of the environmentalists' anti-mining initiatives in the Northwest.
Thank you. This is a Miner's Minute.